Next case is People versus Dupree. This is also a 15-minute mini oral argument on the application. Ms. Guevara, that means you may reserve some time if that works out. And you'll get 2 minutes when we won't interrupt you, and you may proceed.
Good morning, Suzanne Guevara on behalf of Mr. Dupree. I will attempt, if time permits, to reserve 2 minutes. This case boils down to the scoring of offense variables 1 and 2, and whether or not the trial court properly scored these 2 offense variables under the multiple offender situation or provision. Mr. Dupree here was convicted of armed robbery under the aider and abettor theory. And to properly focus as to whether or not these 2 OVs were scored, we need to look at the interpretation of the word offender as the legislator intended in using it. Black's Law Dictionary defines the word offender as a person who committed a crime. So to be an offender then, you must be convicted either by a judge, jury, or guilty plea. That is what an offender means. Therefore, to say that in this situation when there was only Mr. Dupree, one offender, that the multiple offender situation applies, that is an error. All offenders are all those individuals who share a common conviction. We only have one individual, and that's Mr. Dupree. The Court of Appeals opinion states that OV1 requires all offenders to receive the same score without regard to whether the offender or offenders were prosecuted and convicted. To hold this analysis to be true, then we must completely ignore the definition of the word offender and why the legislator intended to use it as opposed to any other word. For example, the legislator doesn't say individual, doesn't say person, doesn't say more than one person, it says offender. And in fact, clearly under OV1, after the scoring is divided, it says all of the following apply to scoring OV1, and that's where the multiple offender language is stated. Therefore, the statement that an aider and abettor shall be punished if he had directly committed the offense does not make this a multiple offender situation. This puts Mr. Dupree in the position of the principal to be convicted of armed robbery. So theory of conviction does not equate finding of fact under the scoring of the guidelines. This court held previously in Johnson that because Johnson was convicted of offenses that were different from his co-defendants, this was not a multiple offender case to score OV1. The prosecution in this case relies on the analysis in the Spicer case, and I believe their analysis is misplaced because Spicer only talked about the application of the guidelines to an aider and abettor. We're not saying the guidelines don't apply to Mr. Dupree. We're saying the multiple offender provision of OV1 does not apply to Mr. Dupree. And the holding in Johnson supports that co-defendants, which don't exist in this case, must share a common conviction. There is no other defendant sharing a common conviction with Mr. Dupree. I cited to Morrison in my brief, and I believe the cases following Johnson and Morrison all come down to the same conclusion, that you need more than one defendant to share a common conviction for this provision to apply. By way of example, and I don't believe I cited this case in my brief, it's Court of Appeals case, so I know it's not binding on this court. I just wanted it as a purpose of illustration. This was People versus Holstag, 2004 Westlaw 2348253. And in that case, the trial court deemed a drug placed in a girl's drink, GHB, to be used as a weapon. There were 2 co-defendants in that case, and for some reason, they scored OV1 for one defendant and not another. And the scoring of those OVs was reversed, finding that even if the 2 acquiesced in putting the drug in the girl's drink, because only one was scored, you can't do that by applying the multiple offender situation. And again, I think the same applies here. We'll have one offender. The legislator intended for this to be applied to a multiple offender situation, and therefore the scoring of these 2 was an error. If there are no other questions, I reserve my remaining time for rebuttal.
Okay, you may reserve.
Good morning. Madam Chief Justice, may it please the court, Aaron J. Hall on behalf of the people of the state of Michigan. This court should deny leave because OV1, the aggravated use of a weapon, and OV2, constructive possession of a weapon, were properly scored as confirmed by the unanimous Court of Appeals opinion. Following a jury trial, defendant was convicted of armed robbery under an aiding and abetting theory. Scoring of OV1 and OV2 does not require the prosecution or conviction of all defendants in multiple offender cases. Rather, the Court of Appeals panel held that OV1 and OV2 require that all offenders merely receive the same score, but without regard to whether other offenders were prosecuted or convicted. Under defendant's proposed rule, an aider and abetter should be rewarded at sentencing merely because the principal evaded capture, simply because the defendant was the first and might be the only offender identified, charged, or convicted of the armed robbery is irrelevant for the purposes of scoring. The guidelines do not include any reference to aiding and abetting because adding that requirement would be unnecessary. Instead, the defendant asked the court to circumvent the plain language of the scoring statutes and usurp the role of the legislature by adding an additional requirement. But this case is not a vehicle to the bright line rule defendant seeks. Despite defendant's assertions, the trial court could properly score OV1 and 2 under an aiding and abetting theory without the prosecution of the principal. And importantly, in this case, defendant's guidelines would not change because the trial court sentenced defendant as a fourth offense habitual offender, which requires a mandatory minimum of 25 years. Therefore, even if the court were to vacate points for OV1 and OV2, resentencing is unnecessary. So we request that the court deny leave and affirm the convictions of the defendant.
Counsel, can you help me out? And even assuming I agree with you that maybe this isn't, maybe that the legislature intended or thought that this, should apply in this situation. What do we do with the provision says in multiple offender cases, if one offender is assessed points for possessing a weapon, then the other shall be assessed the same number. Is that not a condition precedent? The way that the language is worded, that it requires one offender, regardless of the definition of offender, maybe that could be reasonably disputed, but they have to be assessed points. And if there was not another offender, co-defendant, unnamed person assessed points, how does the defendant get assessed the same number of points?
Thank you. I appreciate the question, Justice Kavanaugh. The court in People v. Grow in 2000, this court, settled this question where it said that aiding and abetting does not create a distinct crime. Rather, it allows an aider and abetter to be convicted of, for example, armed robbery, even though the person did not hold the gun or take the money. So in your question, I believe that the the aider and abetter is treated as the principal. So
they are, but I understand that they can be prosecuted and perhaps convicted of that. But when we're talking about scoring a particular OV, it says if one offender is assessed points for possessing a weapon.
correct.
And here, there is no individual who was assessed points for possessing a weapon.
The defendant was assessed points.
Okay.
And it was found as constructively possessing that weapon.
So, okay.
Let me follow up on that. Are you saying now he was assessed points because of what the defendant, in this case, because of what the defendant did, or because of what his co-defendant did?
What the co-defendant did.
If we don't believe the aiding and abetting statute can be used the way you're suggesting, in other words, we take the position that the offense variable statute is more specific to multiple offender situations when it comes to scoring offense variables, do you lose? In other words, can you win without that statute?
I'm uncertain. I think that Justice Viviano, I appreciate the question. I'm uncertain if we lose. I do think that there should be ultimately discretion in the sentencing for the trial court to whether or not the statute requires that all offenders are scored equally. However, the trial court can have the discretion to depart from those scoring if they deem necessary based on certain facts and circumstances. What I'm afraid of and what our office is afraid of is that it can create an unworkable sequence of prosecutions that could make it a defining characteristic.
That sounds like a policy concern that could be addressed. For example, if the statute said if one offender is or could be assessed points, to follow up on Justice Kavanaugh's question. But that's not what the statute says, right? So
Correct.
It's the statute itself that leaves us in this sort of quandary.
Correct. I think that the statute, though, reinforces that points could be proper even when a defendant did not possess the firearm that was pointed at the victim. And
Well,
the
that's
issue,
for sure what it does. But the question is there a condition precedent, and is that condition met here? Let me ask you one more question about the aiding and abetting statute. If we were to accept your interpretation of that statute, would it render all this multiple offender language unnecessary in the offense variable scoring? It appears in, a couple of other offense variables as well, but why would you need that language in aiding and abetting situations?
that I think is what the Spicer court addressed, and then the Grow court focused on as well. But it concluded that the guidelines did not, the guidelines do not include any reference to aiding and abetting because such reference would be unnecessary. So the scoring of OV, all the OV statutes, none of them say aiding and abetting, while they may say multiple offenders.
Should we make anything of the fact that under subsection C, it says a firearm was pointed at or towards a victim, and as opposed to using the active voice that the offender pointed the firearm at or toward a victim?
I think the passive voice is instructive.
Any theory on why the statute kind of switches back and forth? I look at 2C, it says score 5 points if an offender used an object, and D, subsection D, score 5 points if an offender used a chemical irritant.
I do not have any theories as to the legislature's crafting of their statutes.
So I just follow up on one question about, you said that even if the scoring of OV 1 and 2 is incorrect, that it wouldn't change the result here. Isn't that under Francisco, doesn't the defendant have a right to be sentenced according to accurate information, and particularly where it may have some effect on it? Explain why you think that even if your opposing counsel is correct on OV 1 and 2, that this would make no difference.
Well, he was a fourth habitual offender, so his felony status is a mandatory minimum of 25 years.
Well, what if his upper range would change? Is he entitled to that?
So it could be administratively corrected if the court were to find that he needed different guidelines. However, I think in this case, his prior record variable was so high, I think he was a level F at 75 points, and then if they vacated, or if this court vacated OV 1, and it reduced it to 20 points, and OV 2 and reduced it to reduced 5 points, I think the total score would end up being 126 to 420 in the guidelines range. So the guidelines range may change. However, in practical effect, this defendant is mandatory 25. So there's no actual change. with that, we request that the court deny leave and affirm defendant's sentences, unless there are any further questions.
No further questions. Thank you, counsel.
Thank you.
Very brief. First, I want to address your question about whether or not it will make a difference in sentencing. It does. You are correct that Mr. Dupree is entitled to be sentenced under accurate information. The judge sentenced Mr. Dupree to 30 years, 5 years above the mandatory minimum. I would believe it would make a difference for the judge to know that if these two offense variables would not be scored, that may make a difference in the scoring. That would may make a difference in the sentencing of Mr. Dupree, and he may just be sentenced to the 25 mandatory minimum, not 5 years above that mandatory minimum. So I believe that, in my opinion, would make a difference. A few things in response to opposing counsel's argument. I believe that all along they've continued to ignore the meaning of the word offender. And it is a conditioned precedent to scoring these offense variable. If you're going to just go under the theory of the aider and abetter, again, that does not equate to facts the scoring of the guideline. That equals the conviction, but not facts that would require that would need to be true under the definition of offender, as I stated, would equal a conviction. There is only one individual. There's not more than one individual, which makes that inapplicable in Mr. Dupree's case.
What's the, I'm sorry, go
No,
ahead.
please. I bet I was going to ask the same question. So go.
Yeah, okay. I just want clarification on what definition of offender are you urging us to adopt? So-
Black's Law Dictionary defines offender as a person who has committed a crime. And at the beginning of my argument, I say if you have committed.
I have at Black's Law Dictionary definition as someone who has committed a crime, especially one who has been convicted of a crime. But the first part of that would be broader than just someone who was convicted, right?
Well, if a person who has committed a crime, to have committed a crime, you would have to be convicted by a judge, jury, or a guilty plea.
Why?
That what makes you offender. I mean, to become, the statute doesn't say person or individual or a person who was involved in a crime. It says an offender.
If you
And
commit a
the
crime and you're not caught, does that mean you didn't commit a crime?
Well, then you're throwing out the presumption of innocence if you're going to assume that the offender automatically, if you're going to assume a commission of a crime without proof or conviction equals offender. For example, in the situation that if the other individuals, if we're going to assume the other individuals with Mr. Dupree, for the sake of argument, are actually offenders, then we ignore the fact any defenses these individuals might have. We ignore the presumption of innocence. We ignore the fact that maybe a person was acting under duress, or maybe is mentally ill or incompetent, or maybe somebody was holding their family at gunpoint outside that store. I mean, we're then inserting scenarios or assuming that these individuals are automatically guilty. How can we do that without a conviction?
You're reading a little too much into it, I
But
think.
Well,
even if, let's say we don't agree with your definition of offender, doesn't the statute require that the person involved in the crime, even if we take a broader view of the term offender, is assessed points?
I agree. You still need more than one person. It says multiple offenders, and there's only one offender in the situation, even if you were to define
I think Justice
offender.
Kavanaugh's trying to point you in a direction of a
pointing
different
a different
textual
part.
argument. She thinks it's more convincing that the statute says that the other offender is assessed, not could be assessed or is eligible to be assessed. It says is assessed as a condition precedent.
I agree with that,
Do
which
you
is
like
why.
her textual argument better?
Which is why I cited to Johnson and Morrison, because even in the Holstack case that I cited earlier, this was a situation where one person was assessed, co-defendants both acquiesced in putting the GBH in the girl's drink, and one was assessed and the other wasn't, and the Court of Appeals reversed the scoring. So it requires the assessment.
So can we just step away for a second? Why would the legislature want to reward somebody where the principal is not apprehended? Why would the legislature want to do that?
But using the word reward, I believe, is incorrect. This is not Mr. Dupree. It's still scored. His guidelines are still scored as a person who's convicted of armed robbery.
I'll use a different word. Why would the legislature think differently about somebody who is apprehended with two other perpetrators, or somebody who is the only one apprehended and the other two get away? I take back rewarded. I'm just trying to, just help me with You have a good textual argument that Justice Kavanaugh made, but the vibes are bad, right? This is like a classic text versus vibes, and the vibes are bad, right? So why would the legislature care about that? Why would the legislature care about the order of sentencing, which your rule would seem to require? You know, it seems like if your rule is correct in the future, the prosecutor is always going to have to make sure that one defendant is sentenced first before the others are sentenced in a multiple offender situation?
Well, I don't believe that it's the order of sentencing is the proper scoring of the offense variable. I cited to a case in my brief that basically says that to allow, I think it was People versus Ward, where the argument was made that one offense variable was incorrectly scored for the prior co-defendant, and whether or not the trial court, even if it's a different judge or separate trial, is bound by that. And the question was, the order of sentencing is not an issue. You're bound by a correct scoring of the offense variable. So there's not a reward or whatever word you want to use for the order of the trials. I think the legislator in this case, in certain parts of the guidelines, included a multiple offender situation, and that enhances the guidelines. And when there's not multiple offenders, guidelines are still being scored. Mr. Dupree is still being punished, but not as severe as if this was considered a multiple offender situation. As to why they have it in some cases the other, it could be.
So you think the legislature really thought there's a difference between somebody in a multiple offender situation when only one person's, apprehended and where more than one is apprehended? What would that thinking be? I just would love to understand what that would be.
I mean, the way the statute reads, you're supposed to treat all offenders the same. And if you have multiple offenders being scored, they all have to be assessed the same points. So that, to me, would direct the trial courts to assess or to treat the offenders the same. So that if you have one person and you don't have the other offenders, you're not supposed to just punish that person under this theory of multiple offenders. The same example that I just gave with the drink, I mean, because the trial court assessed one and not the other, and the case doesn't mention why the co-defendant was not assessed. They both acquiesced in putting the drink. But I think because the legislators intend whether you need more than one defendant at the same time to be scored. This was the intention. This is the way the statute is written. We're not supposed to add language to it. We're not supposed to abstract language to it. We're supposed to read it as they intended, and the way I read offender, the way all the cases, whether it's from the Court of Appeals or even this court in Johnston, seems to suggest that you need to have more than one defendant. They need to be scored the same. There has to be an assessment to at least one defendant to be able to score the subsequent defendants. And in this case, there was no other defendant but Mr. Dupree, as the Judge Kavanaugh stated, or Justice Kavanaugh, I apologize, stated. I believe that's all my points. Oh, I'm sorry, one last thing. Spicer, again, does not address multiple offender situation. It just addresses the applicability of the guidelines, and I again, believe the prosecution misapplies it to this situation. We're not saying the guidelines don't apply to Mr. Dupree. We're just saying that this provision doesn't apply. If there are no other questions, I conclude.
Thank you very much.
Thank you.
Case will be submitted.